your American dream?
My American dream is to share my culture with you, to learn your culture, and to become one huge ethnic melting pot altogether.
My American dream is for this to be a place where everybody gets along, but everybody can represent who they are proudly and equally. Because we are so proud to be Greek and so proud to be a part of this community that we scream it with the music on the loudest setting so you know we're here. And I hope that one day everybody can be that proud.
Everyone has a right to the American dream.
Groundhog Sam! Oh, hey there, Brad Squad. I hope you had a great weekend. I sure did. And now I'm back in the office. I'm just finishing up some work before Brad Show Live starts. Are you all set for the upcoming immigration show? I know I am. You know, whether you're an aspiring immigrant or already a Groundhog Sam! Oh, hey there, Brad Squad. I hope you had a great weekend. I sure did. And now I'm back in the office. I'm just finishing up some work before Brad Show Live starts. Are you all set for the upcoming immigration show? I know I am. You know, whether you're an aspiring immigrant or already a U.S. resident, watching Brad Show Live could provide you with helpful tips and knowledge to make your immigration journey easier. I know I've learned a lot watching Brad Show Live, and I'm just a groundhog. Imagine how much you could learn. Yep, Brad's going to share tips on navigating green cards, visas, and more. So get ready to learn some new stuff and have a good laugh along the way. Because now is the time you have all been waiting for. It's time for Brad Show Live, starring Brad Bernstein. Enjoy! Enjoy!
And here I am. It is Brad Bernstein. This is Brad Show Live. It is Monday, June 5th, 2023. How is everybody doing? Let me say hello to the squad. Hello, Daryl. Squad up. Pepe Samuel. Squad up. Jessica Limi. Squad up, my loves. Baba Oil. Squad up. How are you? Chetty Manduri. Greetings. Elizabeth Francis, Squad Up family. You know what's great with this new system is you get to see what everybody looks like. Georgia Unbreakable Forster, good evening, squad. How are you, Crystal? Squad Up. RNTI saying, hey, Brad. Kanisha saying hello. Georgia Unbreakable Forster, we already spoke to. Elizabeth Francis, Squad Up. To Jessica Limi. Shireen Cuisine saying, hey, squad. Shireen Cuisine, that rhymes. I like that. Myrtle Ray, Myrtle Ray, Squad Up. Daryl Winnebar, can't wait for the show to start. Well, here we are, Daryl. Lisa B, Squad Up, how are you? Shireen Cuisine, of course, my face is being blocked. Shireen Cuisine with a pre-Schmooze question of the day. If 60 days passes since the RFE, which is a request for more evidence, well, in this particular case, a marriage case, more marital evidence, and she responded, nothing happened, what's the best thing to do? What if they say not received? Well, hopefully they received it. If they didn't receive it, they're going to deny your case. So I don't think that's the issue. If 60 days has passed and you submitted the RFE, first of all, they have up to 120 days to respond to an RFE. So 60 days is no big deal. But if 120 days comes and goes and there's still no response, expect an interview. if you submitted enough documentation, then you will not get an interview and it will be waived. So hopefully you submitted enough, but I'm sure it was received. But if it, for whatever reason, gets lost in the mail, then of course, obviously, your case would be denied and you would have to do a motion to reopen. But let's not think the worst. I assume, you got to assume if something's put in the mail, it's going to be received. Tammy Ives, hey squad. And let's see, Westman, squad up. How are you? Jewel Delph, squad up. Uju, squad up. And Georgia Unbreakable Forster also with the pre-schmooze question of the day. How soon can I file my citizenship? In September 2023 makes 5 years. 90 days before September 2023. So we're now June 2023. Well, I don't know what day in September 2023. So let's call it July 1st, because you got July is 31 days, August 31 days, unless you got it like September 27th. Let's call it July 7th. That way, any day you received it in September, you're good. Any day, there's my answer. I just did the math in my head. Any day after July 7th, 2023, Georgia Unbreakable Forster, you can file for your citizenship. And Sophia Henderson, good afternoon. Rachel Lewin, hey, Brad, another pre-schmooze question of the day. Hi, Brad, a loyal Brad fan waiting for you from 5 p.m. I want to know the latest on the backlog from family petitions. All right, I can pull that up on my phone. You want me to do that? That's not a problem. I can do that very easily. I should have had it handy before I started, but I didn't. U.S. Visa Bulletin. We just Google Visa Bulletin on Google, and we get to travel.gov.state, and we go for June 2023. Latest on the backlogs. Are you talking about what the visa waiting list is right now? For dates for family sponsored applications, F1 applications, which are unmarried sons and daughters over the age of 21. This is for every country but China, India, Mexico, and Philippines. January 1st, 2017, F2A is current, meaning spouses of residents are current. Children under 21 of permanent residence, current. F2B, children, unmarried children above 21, January 1st, 2017. F3, which is married children of U.S. citizens, February 8th, 2010. F4, brothers and sisters, February 1st, 2008. I assume that's what you were asking. God's Warrior. Nobody sees my mouth move, just a nose and eyes. Now just a bald forehead. All right. What if I came in and after a few months, I'll just raise my head. A few months, I guess, adjusted my status, but had a family emergency. My mom was about to die. I left to go support. By miracle, she's still alive. When you filed your adjustment of status, well, first of all, by miracle, she's still alive. Thank God. That's most important. If you filed your adjustment application and you left without permission, which is the advanced parole, then you can't, then that's the end of the adjustment application. So your adjustment application's been denied unless you had advanced parole. And if you entered on a tourist visa or on any non-immigrant visa other than an H-1B or an L, which is dual intent visas, but any other visas non-immigrant, then you violated that non-immigrant intent by filing an adjustment application. That visa is no longer good and they're not going to give you a new one. So whoever filed for you would now have to file an I-130 visa petition for you to get your green card in another country, which will take some time, unfortunately. Kanisha. Okay, we're all laughing. Digital Wealth, also with a pre-schmooze question of the day. I guess he's into Bitcoin, digital wealth creations, perhaps. He's a Bitcoiner, maybe. Can you explain a new law about the vaccine that came out on May 12th? Well, that is a new law that says if you're coming here on a non-immigrant visa, you don't need a vaccine. But if you're applying for a green card, you still need a vaccination. That law has not changed, a COVID vaccination, or you need to file a waiver based on religious grounds or moral objections that you refuse to take the COVID vaccine. based on your moral objections. I would say it's more likely now to get approved than in the past because the COVID pandemic is over, but not a guarantee. There's never a guarantee to get the waiver for the vaccine approved. I would say when COVID was rampaging through the United States, it would have been very difficult. Now it's probably more likely to get approved as long as you have really good moral objections, but it's still never a guarantee. So if you're applying for the green card and you want a guarantee of getting a green card, you take the vaccine, like it or not. You want to file the waiver, roll the dice, and if they deny you, then you would have to refile all over again. You can do that as well. It's not the end of the world. And I would say you have a better chance now in 2023 than you did in 2021 or 2022 for sure. But the law is just for people coming that you don't need you don't need to prove vaccination just for your visitor's visa coming anymore, or renewal of the visitor's visa. Becky saying hello. Jewel Delph, squad up. And Duma Nunu David, also with a pre-schmooze question of the day. Hi, Brad. Can I change lawyers, affect my case because I'm thinking of changing my lawyer? Well, if you're changing from a bad lawyer to a good lawyer, I think it'll affect your case very well, positively. If you're changing from a bad lawyer to a worse lawyer, I think it'll make your case worse. But you, my friend, Mr. Dun Minunu, David, are the captain of your own boat. It's your life. You get to choose your lawyer. You can switch lawyers whenever you want. It affects your case positively if you switch to a better lawyer, and it affects your case negatively if you switch to a worse lawyer. But the actual act of switching a lawyer will have no effect on your case whatsoever. And Sophia Henderson also with a pre-schmooze question today. A lot of pre-schmooze questions today. Uncle Brad, I'm asking for a friend. Everybody always says, yeah, when asking for a friend. But okay, Sophia, you're asking for a friend. Uncle Brad, she got an RFE for an I-130A. She submitted a month ago, but has not seen what they say. They received it filed electronically. Well, if you did it properly and you didn't hear anything, then everything's fine. So if you got an RFE for an I-130A, that was an RFE that came right at the beginning of the case because you didn't submit all the documents. Now you submitted all the documents. Presumably now you should be getting your work permit and travel document, and your case is processing along. So the only reason you would hear from them within a month or two is if they deny your case. So the fact that you didn't get denied is positive, and presumably your case is processing along right now. All right, we're going to do one more pre-schmooze question of the day, I think, and then we're going to get into our schmooze. Of course, later on, I'm going to answer everybody's questions in the comment section. I'm also going to take telephone calls as well. Let me just do one more pre-schmooze question of the day. Oh, we did that one. Level up with a pre-schmooze question of the day. Someone I know is over 21 and their citizen parent filed for them while in the United States. Adjustment status was denied, but the I-130 was approved, but the visa won't be ready anytime soon. Do they have another option? Yeah, figure out a green card another way, but there's no option on that parent. You got to wait on the I-130, then do a provisional waiver, go home and come back. All right, we're going to do the rest of our questions later, and want to say hello to everybody. If I missed you, I'm very sorry, but we can sit here and say hello to everybody for 2 hours. Trust me, I see you, and I appreciate you watching the show, but I think it's time to do something we like to call, before we go to do something I like to call schmooze, got to remind everybody that you can call our office at 212-227-8933. That's 212-227-8933. Internationally, within the United States, it's 1-800-529-5465. That's 1-800-LAW-LINK, 1-800-529-5465. And that is not only the number to call my office to schedule a consultation with me, it's also the number to get on our show. Right now, our phones are locked. But you save that number for the rest of your life. Put it in your phone. Dial it and hang up. And you have that number saved for life. 1-800-529-5465. Internationally, 212-227-8933. And you put down Brad Show Live, really good lawyer, whatever you want to write in your phone. So you remember when you need a good lawyer, because maybe you don't need one today, but you need one tomorrow. And coming up after I do our schmooze, and for those who don't know what the schmooze is. You'll see very soon. I'm going to be answering your calls, the viewers' calls, live by calling that same number, 1-800-529-5465. But right now, I think it's time to do some schmoozing. Let's do it. So, effective as of May 31st, the U.S. Citizenship and Immigration Services has changed the filing location for affirmative asylum applications submitted by mail. They say this change should help streamline the processing and improve adjudication efficiency by digitizing paper filings for asylum. And you should now mail your Form I-589, the application for asylum and for withholding of removal, to the lockbox that has jurisdiction over your place of residence instead of to the service center. Now you go to the Where to File section of the Form I-589 webpage to learn where to file your application. If filing by mail, you should file at the appropriate lockbox location to ensure timely receipt of your application. Applicants who submit a properly filed Form I-589 to a lockbox, they're going to receive 2 notices. The first notice is going to acknowledge that the lockbox has received and forwarded the asylum application to USCIS. And after USCIS accepts the application, they will issue a standard asylum receipt notice. Both notices will include the same receipt date that is used to determine eligibility for employment authorization based on a pending asylum application and for purposes of the 1-year filing deadline. Online filing is also available and encouraged for affirmative asylum applicants who are not in immigration court proceedings and who do not have to submit their application to the Asylum Vetting Center. So a new process for the asylum applications. And asylum seekers say joy over the end of the public health restriction known as Title 42. If you've watched our show for the last 6 years, it's all we've talked about, at least if not on every show, every other show, because it ended on May 11th. However, it is turning into anguish with the uncertainty about how the Biden administration's new asylum rules are going to affect each of them individually. Though the U.S. government opened some new avenues for immigration, the fate of many people is largely left to the United States government's CBP, the Customs and Border Patrol One app. And that is to be used by anyone on the Mexican side of the border who is coming to the southern border of the United States trying to apply for asylum. And you use the government's CBP One app to schedule an appointment at a port of entry. However, a lot of people, including myself, are saying that CBP app is really not fair because it is unable to decipher human suffering, weigh the vulnerability of applicants, weigh how good of a case or how harsh of a reality people are living in right now. And it's just basically by luck if you are able to get an appointment. Now, the Department of Homeland Security said the CBP One app is a key tool in creating a more efficient and orderly system at the border while cutting out unscrupulous smugglers who profit from vulnerable migrants. But since its rollout in January of 2023, the app has been criticized besides for technological problems. It's also been criticized because the demand for appointments has far outstripped the roughly 1,000 appointments available each day. And there does not seem to be an option right now for people to ask for asylum if they don't make an appointment through the CBP app. So it is either the CBP app or nothing. And as a result of all of this, there are, as you can imagine, plenty of lawsuits. The Center for Gender and Refugee Studies is one of the lead plaintiffs, along with the American Civil Liberties Union, challenging some of the new rules in federal court in San Francisco, including the circumvention of lawful pathways rule that requires people to first apply for asylum in a country they crossed on the way to the United States. So that rule really means that unless you're a Mexican citizen, you can't apply for asylum if you crossed over the border without inspection. And this lawsuit is asking the court to allow an asylum request by anyone on United States soil. Texas Republican lawmakers have also sued. Among other things, they argue that the CBP One app encourages illegal immigration by dispensing appointments without properly vetting whether applicants have a legal basis to stay in the United States. Texas is also part of another lawsuit accusing the administration of overstepping its authority by allowing as many as 360,000 people a year from Cuba, Haiti, Nicaragua, and Venezuela to enter the United States under its humanitarian parole authority. But the Biden administration said the new measures, including the app, have helped reduce unlawful immigration by more than 70% since Title 42 ended on May 11th. And the United States government stated that more than 79,000 people were admitted into the United States under the CBP-1 app from its January 12th launch through the end of April. And from May 12th to May 19th, the average of 1,070 people per day presented themselves at the ports of entry after securing an appointment on this CBP app. The administration has also made improvements in recent weeks. According to the Biden administration, the app can prioritize those who have been trying the longest now. And on Wednesday, the Department of Homeland Security officials told CBS News that the Biden administration is expanding the processing of asylum seekers along the U.S.-Mexico border by admitting nearly 40,000 migrants at official crossings each month. And starting this month in June, officials are going to allow more migrants waiting in Mexico to secure an appointment to enter the United States through the CBP-1 government phone app. And DHS officials said U.S. border officials will now distribute 1,250 appointments each day, which is a lot more than the 1,070 up until June 1st. And that's roughly going to be 38,750 appointments each month for asylum at the southern border between Mexico and the United States. And those appointments are going to go to migrants who are waiting in Mexico so they can present themselves at a port of entry for an opportunity to be allowed into the United States and request asylum. Previously, U.S. officials processed just 20,000 asylum seekers each month under the old CBP-1 system. In a statement, DHS said it would evaluate whether to expand port of entry processing even further into the future. And the pumpkin is back in the news every day. It doesn't end. We thought he would no longer be president. We'd get rid of him. Nope, he's just as bad from his pumpkin headquarters in Florida. He's running for president. He's now leading the Republican field. And his number one immigration priority, he says, when he becomes president again, if he becomes president again, is to remove birthright citizenship. On May 30th, Donald Trump, Mr. Pumpkin, he announced he would seek to end birthright citizenship by executive order on his first day in office. Trump announced his plan on the 125th anniversary of the United States versus Wong Kim Ark, the Supreme Court case that established the constitutional right to birthright citizenship. Now, most experts agree, including myself. I haven't seen an expert who doesn't agree with this, that a United States president has zero authority to end birthright citizenship through an executive order, primarily because the practice is enshrined in the Constitution of the United States, according to the Supreme Court decision, United States versus Wong Kim Ark. And the 14th Amendment grants citizenship to those born or naturalized in the United States and subject to the jurisdiction thereof. And this widely accepted interpretation of that amendment, and that applies to children born in the United States, regardless of parents' immigration status, has been the law since 1898. And the 14th Amendment, for those who don't know, was adopted after the Civil War to guarantee equal rights for former slaves. Immigration restrictionists argued that excludes the children of other groups like undocumented immigrants and its benefits. So the amendment was put into place for to make citizens of slaves, former slave citizens, and their children citizens. And the Supreme Court said in 1898 it also is to any immigrant who has a child who's born in the United States, no matter of their immigration status. And according to the Trump campaign, the executive orders will explain the clear meaning of the 14th Amendment. Trump disagrees with what the 14th Amendment says. And he says that the children of foreign nationals born in the United States are not subject to the jurisdiction of the United States as defined in the Constitution. And during Trump's term in office, a draft executive order to that effect was previously circulated. The idea was revived shortly after Trump's loss to President Biden, but he never actually signed the executive order. Now, while an executive order altering the interpretation of the 14th Amendment is likely to face legal challenges, its proponents sought to take the case to the courts in hopes of eventually getting a favorable Supreme Court outcome with a 6 out of 9 majority of conservative judges, and also to start the process of having a conversation, a political conversation, a social conversation that's being held in the news by political pundits about what it means to be a United States citizen, and Donald Trump wants to change that. Hopefully, he doesn't become president. Now, pressure is growing for a boycott in Florida, including Latino truck drivers who vow to stop deliveries across the entire state of Florida. And on June 1st, many Florida businesses shuttered their doors for the day in an immigrant labor strike to protest Governor Ron DeSantis' sweeping new immigration law. The Republican presidential hopeful has railed against U.S. immigration policies and newly arrived asylum seekers for year after year. Florida Senate Bill 1718, which takes effect on July 1st, will offer a preview of the controversial changes DeSantis has said he'd like to see Congress implement if he actually becomes president. Among its provisions, the strict new state legislation in Florida limits social services for undocumented immigrants, allocates millions more tax dollars to expand DeSantis' migrant relocation program, invalidates driver's licenses issued to undocumented people by other states, and requires hospitals to get Medicaid dollars to ask for a patient's immigration status. All of this, by the way, there will be a lawsuit on July 2nd because all of this likely is in violation of the Interstate Commerce Clause of the U.S. Constitution, where each state has to obey the laws of other states in terms of interstate commerce, as well as, so for people who don't know, the Interstate Commerce Clause is what the federal government used to invalidate the Jim Crow laws during the civil rights movement in the 1960s, to say that, for example, you can't discriminate against people because of their color of their skin. It's in violation. Federal government law trumps, I don't hate to say the word Trump, but overcomes the state law because the federal government has a say in interstate commerce, that people who are driving from one state to the other should not be subject to Jim Crow laws under the federal law. So all of this probably, I'm not a constitutional scholar, but probably is also invalid under the Interstate Commerce Clause. So there'll probably be lawsuits about that as well. Going back into the Florida law, there are penalties for businesses and undocumented immigrants alike who violate new employment mandates. All of this will be in lawsuits. Whether or not judges put a stay on enforcing this legislation, we'll see in the end of July, early August. Supporters say it's going to expel the recent influx of immigrants who arrived in Florida and provide more job opportunities to citizens and others in the country lawfully. And critics say it will cost the state billions in lost revenue, while many of the harshest penalties are unlikely to be enforced. Now, if Florida is actually going to enforce all of these laws, this is what it's going to look like. To crack down on businesses hiring undocumented workers, SB 1718 is going to require private employers with 25 or more employees that are making new hires to use E-Verify, the federal online database that employers use to confirm whether someone is eligible to work in the United States. Samuel Santiago, a Florida director of the American Business Immigration Coalition, an advocacy group for immigration reform that benefits businesses, told NPR News that the change will likely have a significant impact on Florida's agriculture, orange groves, construction workers, and the hospitality sectors, industries where immigrants make up a vast majority of workers. And not allowing businesses to be able to utilize these workers will have a really big impact on the economy and the ability to create jobs in Florida. And that's a big problem for Florida, where there's already a widespread labor shortage. The unemployment rate in Florida is just 2.6% in April. So the supporters of this law says that this is going to open up jobs to American workers. What American workers? The unemployment rate is 2.6%. Ask any economist, 2.6% unemployment is full employment. The Florida Policy Institute, a nonprofit policy research group, estimates that without undocumented workers, the state's most labor-intensive industries would lose more than 10% of their workforce and the wages they contribute along with them. That could lead to a drop of $12.6 billion in gross domestic product in Florida in 1 year. That's a loss of more than 1.1% of the entire gross domestic product of the state of Florida, which would in turn cut workers' spending powers, reduce state and local tax revenue. There's been a wave of videos on social media showing images of vacant construction sites, vacant fruit and vegetable fields where harvests remain unpicked, and where fruits and vegetables are rotting. According to the video's narrators, the job sites have been abandoned by people who fear the new bill's e-verify requirements. A graphic on governor's website states that employers who fail to use the e-verify will be fined $1,000 a day. For workers, it will be a felony to use a false ID to get a job. The legislation clarifies that these penalties apply only after an employer fails to use the database 3 or more times within 2 years. And under the new law, a person who transports into Florida someone they know or should have known is an immigrant who has not been inspected by authorities could be charged with felony human smuggling. Now, a person who is found transporting fewer than 5 immigrants on their first offense could be charged with a third-degree felony. They can be sentenced to up to 5 years in prison or pay a fine of $5,000 or both. Now, you may be an American citizen driving your spouse who is undocumented into Florida. That would now be a third-degree felony. The Florida Policy Institute estimates that there are 130,000 U.S. citizens in Florida who are married to undocumented immigrants. That potentially is 130,000 felons. It is conceivable that under the law, a U.S.-born spouse traveling from out of state, as I just said, could be charged with a third-degree felony. Similarly, farm workers who travel together or with family could also be charged. Now, don't freak out. Nobody is arresting anybody for felony for being married to an undocumented alien tomorrow. Somebody eventually will get charged and there will be a lawsuit and it will go all the way up to the Supreme Court. And probably all of this will be on hold while this goes through the court system. But it is pretty scary stuff, what's going on in Florida. And on May 22nd, a group of Chinese citizens who live, work, and study and raise families in Florida, as well as a real estate brokerage firm in Florida that primarily serves clients of Chinese descent, filed a lawsuit to combat Florida's discriminatory property law, SB 264. This law, signed by Governor DeSantis, the legislation restricts most Chinese citizens and most citizens of Cuba, Venezuela, Syria, Iran, Russia, and North Korea from purchasing homes in the state of Florida. Unless the courts act to reverse this law, it is going to take effect also on July 1st, 2023. The plaintiffs are represented by the American Civil Liberties Union, the ACLU of Florida, the Hang Law Office PC, and the Asian American Legal Defense and Education Fund. The lawsuit argues that SB 264 will codify and expand housing discrimination against people of Asian descent in violation of the Constitution and the Fair Housing Act. It will also cast an undue burden of suspicion on anyone seeking to buy property whose name sounds remotely Asian, Russian, Iranian, Cuban, Venezuelan, or Syrian. Governor DeSantis has argued that this law is necessary to protect Florida from the Chinese Communist Party. But this rationale equates Chinese people with the actions of their government, and there is no evidence of national security harm resulting from someone with Chinese passport owning real estate in Florida. Ashley Gorski, senior staff attorney with the ACLU's National Security Project, said, "Everyone in the United States is entitled to equal protection under our laws, including citizens of other countries. If SB 264 goes into effect, it will profoundly harm our clients and countless other immigrants in Florida." Florida's new law is similar to efforts over the past century to use claims of national security against Asian immigrants and other marginalized communities. In the 1800s and 1900s, a number of states, including Washington and California, had laws known as the Alien Land Laws, barring non-citizens ineligible for citizenship to own real property. The laws targeted Asian immigrants who, as non-whites, were ineligible for naturalization. And these policies not only hurt immigrants financially, but also exacerbated violence and discrimination against the Asian community. Over time, these laws were struck down by the courts or were repealed by state legislatures because they violated the Constitution's equal protection guarantees. Over a dozen state legislatures have recently introduced similar legislation, and many of these bills likewise target people from China. Florida's bill was the first of this wave. Daniel Tilley, the legal director of the ACLU of Florida, said Asian immigrants are part of Florida's fabric. For hundreds of years, they've contributed to our communities and have made this state their home. The discriminatory policies pushed by the DeSantis administration will not go unchecked. And according to the State Department data in 2022, consular officers denied a record 220,676 student visas. This means 35% or more than 1 in 3 student visa applications were denied, the highest denial rate ever. David Beer of the Cato Institute attributes the change to a shift in the number of Chinese and Indian applications. Chinese visa applications that are granted 2 to 4 times more often than Indian applications are trending downward, which reduces a reliable stream of visa grants. Meanwhile, Indian visa applications are more likely to be denied, and those are going also down. Beer writes, and I'm quoting, "This is a disaster as student visas are the jumping off point for most skilled immigrants. So the impacts will be felt by employers. Immigrants study at America's elite universities and then find jobs when they graduate, largely through the postgraduate employment authorization program called optional practical training. Despite the importance of these student visas, the State Department rejected an unprecedented 35% of student visa applications in 2022. Student visas are known as F1 visas. Student visas usually have a similar rejection rate to other non-immigrant visa applications, but in 2021 and 2022, student visas have been denied at double the rate of all other non-immigrant visa applications. So the student visa denial rate has increased from a low of 15% in 2014 to 35%, which is the highest ever in 2022. It is also consequential, for universities. Before a student can even apply for a visa, they must already be accepted into a government-approved university. This means the U.S. Department of State turned down 220,676 students who would have likely paid roughly $30,000 per year or $6.6 billion per year in tuition and living expenses, and spent even more money in the United States. And over 4 years, that number rises to $226.4 billion in lost economic benefits to the USA. The State Department does not separately delineate the reason for student visa denials, but nearly all non-immigrant visa denials are for failing to prove non-immigrant intent. That is, the desire not to move to the United States permanently. Applicants need to show sufficient ties to their home country that would impel them to return to their home country when their reasons for visiting as a student have ended. Consular officers are supposed to only consider someone's present intent, not considering how their intention might change if opportunities arise in the United States. Another ground for denial, which is less frequent but affects many students from China, is a Trump presidential proclamation that bars visas for people who studied at any university that works with the Chinese military on any level. Another reason that may explain the increase in denials is that after major delays during the pandemic, Indian consulates issued an unprecedented 115,115 student visas, by far the highest total for India ever. But according to data obtained by researchers via the Freedom of Information Act request, before the pandemic, U.S. consulates in India are far more likely to deny students than U.S. consulates in China. This means that the surge in processing in India, combined with fewer Chinese applicants, has likely caused a large increase in the worldwide average denial rate for students. And Prince Harry is still in the news. A conservative think tank will argue in front of a federal judge tomorrow on June 6th at the U.S. District Court for the District of Columbia that Prince Harry's U.S. immigration records should be unsealed in light of revelations about drug taking in his recent book. The Heritage Foundation is suing the U.S. government to find out if it acted according to procedure when it granted the Duke of Sussex a U.S. visa. Under U.S. immigration law, evidence of past drug use can be grounds to reject an application if it is considered proof of current drug abuse. The Heritage Foundation filed a complaint under the Freedom of Information Act attempting to compel the government to release Harry's immigration file. An amended complaint filed on May 5th reads, widespread and continuous media coverage has surfaced the question of whether DHS properly admitted the Duke of Sussex in light of the fact that he has publicly admitted to the essential elements of a number of drug offenses. The Heritage Foundation is one of the most influential conservative think tanks in Washington. Niall Gardner, ironically, the director of the foundation's Margaret Thatcher Center, Margaret Thatcher being the former Prime Minister of the UK, he tweeted on Thursday that there was a public interest in disclosing Harry's records. He tweeted, quote, giving his extensive drug use admissions, normally disqualifying for entry into the United States, the American people deserve answers to a very serious question raised by the evidence in Harry's book. Did DHS, in fact, look the other way? Harry recently confessed to taking various recreational party drugs in his memoir, Spar, which was published in January. Elsewhere in the autobiography, he disclosed graduating from smoking tobacco to weed during his days at Eton College. And previously, Harry spoke with Oprah Winfrey on how he abused drugs. And past drug use, in my opinion, as a lawyer, I think I know, past drug use does not mean you are a current abuser of drugs. And as long as it was years and years in the past, I think the Duke of Sussex is going to be okay. And finally, Yemi Mobolade, a Nigerian immigrant and businessman with no political experience, is going to become the first elected black mayor of Colorado Springs, Colorado, after he defeated Wayne Williams on the evening of May 16th in the city's runoff contest. Mobolade has received 57% of the vote to Williams' 43%. Mobolade will succeed Mayor John Suthers, a former federal prosecutor and Colorado State Attorney General, who was term limited. Mobolade's decisive victory represents a political earthquake in Colorado Springs, Colorado, which is, by the way, Colorado's second largest city. This is not small little village town. And Colorado Springs, Colorado, long known as a conservative stronghold, yet they voted for Mobolade. Now, Mobolade, he's a married father of three. He moved to Colorado Springs in 2010 and became a leader in the business community. He co-founded two popular restaurants, the Wild Goose Meeting House and Good Neighbors Meeting House, and served as its small business development administrator. He was also the vice president of business retention and expansion for the Colorado Springs Chamber and Economic Development Corporation. Leon Young was Colorado Springs' first black mayor, though he wasn't elected to the position. Young was elevated to interim mayor in 1997 after the resignation of Mayor Bob Isaac. Mobolade kicked off his victory speech by saying, "Wow, wow, I am speechless." And he closed out his victory speech by announcing that his father passed his U.S. citizenship test just the week before the election. He said, greater things are yet to come. Greater things are still to be done for the city. And that, my friends, is our schmooze of the day. Before we get to your viewer calls, I do want to tell a quick story about Tracy, a Spar and Bernstein success story. Tracy grew up in the United Kingdom, had a child at a young age. She moved to the United States to give her son a better opportunity, and she built a successful business in Brooklyn selling African products and handmade items. But for 19 years, Tracy lived in America out of status. She tried finding a path to a green card with other attorneys, but having no success. When she came to Spar and Bernstein, she was losing hope that she would ever gain her permanent residence. but we kept her faith up. And 2 years later, Tracy and her son both received their green cards. Tracy spoke to us when she came to pick up her green cards and that of her son about how having permanent residence, especially as a recording artist and an entrepreneur, would be life-changing for her. Let's watch.
My name is Tracy Reed, and today I'm here because I got my green card. I'm also a recording artist, Fireheart, reggae recording artist, so now I'm looking forward to going more international and getting more of my material out there, and I'm really excited. And thanks to the owner here, Spar and Bernstein, that I was able to acquire my green card in the United States. I'm also a Canadian citizen, but it's been a long journey, and I've been through so much, and I'm just so glad to be a client of Spar and Bernstein. And anyone out there who knows me in Brooklyn or anywhere in the world, I'm saying that this is the company that you need to come to, and they will take care of you to the end. And just be committed on your portfolio, and you'll be successful like myself.
How long were you in the United States before you got your green card?
Oh my gosh, as it's been 1999. I started my company in 1999, and I came to this firm just a few years ago, maybe 2 or 3 years ago, and we they put it together. They made it happen. Come get your help. Don't procrastinate. Don't think that it's too much money. They have different payment plans here. They'll work with you, and they'll make things possible. And no one should be in a country that you're unable to travel and able to move around. Blessings to everyone out there. And I'll see you Jamaica. I'll see you England. I'll see you Toronto very soon. All right. Thanks. You're welcome.
Congratulations.
Thanks.
And you never know what your options are until you come in for a consultation. Together, we will try to find a path to legal status for you. Send us a private message or give us a call at 1-800-529-5465, internationally 212-227-8933. People always ask me all the time, what if I don't live in New York? Well, there's a telephone. You speak to me over a telephone from wherever you are in all 50 states. I can handle your immigration case in all 50 states. I can handle it in California. I can handle it in Alaska. I can handle it in Florida, in Texas, in Illinois, Pennsylvania, Maryland, Boston, Connecticut, you name it, all 50 states. We can do everything by phone. So all you have to do is call 1-800-529-5465, internationally 212-227-8933. And of course, internationally, I can handle in every country you are in the world. All right, let's get to our viewer questions, our meat and potatoes. Let's do it. All right, let's go to Anne-Marie in Dallas. Anne-Marie, how are you?
Hi, Brad. How
Hi,
are
Anne-Marie.
you?
Good.
Hi. So I have a couple of questions for you. So I'm a permanent resident. I petitioned for my daughter. However, the case is at NVC now. In December, I got a letter from them that the case is documentarily complete since December 16, 2022. And but they're still waiting for a date for her.
What country is your daughter?
From Jamaica, but she's here.
Okay.
She's here. She's here. Mm-hmm.
Is she here in legal status or out of status?
Out of status.
Did you do a provisional waiver for her?
I'm not sure.
If you're not sure, the answer is no.
Visa.
Okay.
Pardon me?
If you're not sure, then the answer is no. So you're scheduling your daughter to go back to a appointment in Kingston, Jamaica, where she's eligible for a green card, after she has overstayed her visa in the United States by how many years?
She's here from 2016.
Okay. How old is she?
She will be turning 18, 1st of August this year.
Okay. All right. So, a couple things. Your daughter has to leave the United States within 180 days of her 18th birthday. So she will turn 18 this August. So she would have September, October, November, December, January, By the end of January of 2024, she's got to be out of the country or she's starting to get banned. She has no ban up until 180 days after her 18th birthday, so she's okay. It's taking about 1 year to schedule. How long do you have a green card?
Yes, I have a 10-year.
How long have you had a green card?
Since 2019.
How did you get your green card?
Through marriage.
Are you still married?
No.
No. Okay. All right. When in 2019 did you get it? What month?
August.
Okay. All right. So this is my advice, because you're not going to become a citizen until 2025. And your daughter may be 21 by then. It's taking about 1 year to schedule an appointment in Jamaica. So if you were documentarily qualified by December 2022, by December 2023, there should be an appointment. As long as your daughter returns to Jamaica before the end of January of 2024, she will not have a 10-year bar. She will be okay. And she'll go home for about 10 days, get her visa appointment, and return. But you got to remember, she's got to be out of the country within 100. I can't calculate the date right now because I'm live and I'm not good at math, but it's 180 days after her 18th birthday. But she should get her appointment before that. So you're asking me, I guess your question is, when will she get her appointment? I don't have a magic 8 ball. I don't know. But generally it's within 1 year, but you're of documentarily qualified. So she should have it by December of this year if everything is done right. She's got to be out of the country by January of 2024 for sure. So my advice would be, we're now in June. If by the end of September she does not have a visa appointment, I want you to call me and have a consultation.
Okay.
You seem unsure.
No, I will.
Okay.
I will. If by the end of September we doesn't get an
if she
appointment.
gets an appointment before September, just as long as you're confident that everything was done well, you can send her home and she'll be back. All right. But have an appointment with me 90 days before that 180 day. She has to be out.
Okay.
But she should have it by December for sure. But maybe sooner.
Okay. But are you saying if they doesn't give her, if she does get an appointment,
what I'm saying is she has to be out of the country. Take her birthday, add 180 days. She has to be out of the country by that day, appointment or no appointment.
Okay. So if no appointment and she go out, will she be okay to come back when she get the appointment?
100%. She did not violate any law that would bar her from getting a green card as long as she leaves within 180 days of her 18th birthday.
Okay, got you.
That's the key. That's the key thing.
Okay.
All right. When she'll get an appointment, I don't know, but probably by the end of the year. That's why I wanted to speak to you at the end of September, so we're all on the same page and you know what to do.
Okay, got you. One last question.
Yes.
Is the vaccine, the COVID vaccine, is a requirement because she hasn't been vaccinated?
Yes.
Okay.
You can ask for a waiver. It's going to delay her case and there's no guarantee it gets approved.
The waiver?
There's a waiver for the COVID vaccine based on moral objections. You need a good lawyer to argue that out. There's no guarantee that waiver gets approved. It delays her case by months, so she would be stuck in Jamaica for months and months longer. And if it's denied, then she's stuck for life. So you don't want, you're taking a chance honestly, you're taking a chance by taking the vaccine. You're taking a chance by not taking it. There's no right answer.
Yeah. Okay. So you advise us for her to get it now before she get an appointment.
Correct.
Okay.
Correct. And then she has no problem.
Thank you.
All right.
Okay. Thank you so much. Bye-bye.
Let's go to Erica in Wisconsin. Erica.
Yes.
How are you?
I'm good. How are you?
Good. What can I do to help you?
I have a question about my husband who. Hello.
I'm listening, Erica.
Okay. We're in a bit of a mess with my husband who is in Singapore. We are unsure if he's been given a ban. So what happened was we were living in Singapore and we came to the U.S. as boyfriend, girlfriend, and got married. And he had entered under an ESTA visa. And we came to the U.S.
Could you lower your computer or phone and just talk to me normally?
Okay.
Background.
Yeah.
You're a U.S. citizen. And what happened after that?
And then, he was under an ESTA visa, and we got married, and we weren't thinking of it like what it would look like from an immigration point of view. We were just thinking of it as ourselves. So then he left back to Singapore for a month, and then came back into the U.S. And we filed the I-131 spousal visa.
I-130.
And then. Okay, and then he was unable to legally work here. So he sat around for 10 months and he was kind of like really sick of not working or not having an income. So he's like, well, and then he had applied for the adjustment of status, the 485. But he didn't have the patience, and he was like, I'm going to go back to Singapore and work for a few months. And, I'll come back.
Okay, so all right, so this is the answer. This is the answer.
Mm-hmm.
Okay.
Mm-hmm.
He came here, he came here on an ESTA visa, filed an adjustment,
Mm-hmm.
and then left without advance parole.
Mm-hmm.
So
Mm-hmm.
two things happened. One, when you leave the United States without advance parole after filing an adjustment of status application, that's the end of the adjustment application. Denied. Got it.
Mm-hmm.
So he has nothing processing. Number two,
Okay.
if you come on an ESTA visa and file an adjustment, you're not getting a new ESTA. You're not getting any visa.
Mm-hmm.
I don't believe he has a 3 or 10 year bar, because I presume he filed an adjustment application within 180 days of him overstaying his visa. So he doesn't have a 3 or 10 year bar. Perhaps he may have a bar for misrepresentation if he came on the ESTA visa and filed an adjustment within the first 30 or 60 days. But you have to file a new I-130 visa petition for him to pick up a green card in Singapore. And it's going to take, 2 years, and hopefully he doesn't need a waiver.
So he was deported from San Francisco.
Why was he deported?
That's
new facts to this situation. Why would he be deported?
That's the whole problem, is they didn't communicate with him at all. They just took his passport and his phone.
Who's they? Why was he deported? You're not telling me a story. Why was he deported?
He doesn't know. They did not.
Why did immigration come and knock on your door, Erica?
No. Sorry. So, okay. He went.
You're not telling me the right story, so I can't answer you if you don't tell me the right facts.
So he went back to go earn an income.
And then he came back on the ESTA visa.
Singapore. I got a letter in the mailbox.
Okay, all right. So he screwed up 10 different ways. Got it, Erica.
And then
Erica, stop.
Then I'm like,
Erica, stop. I
back.
got it now.
Mm-hmm.
Erica, stop. Because you don't tell it. I mean, I could fall asleep by the time you tell me the story. So you filed the adjustment application. He went home and then tried to I could have said this in 5 words. He filed an adjustment application, went home, and then tried to re-enter again on the ESTA visa, and he got deported. So now he may need 2 waivers. He's barred for life because he unless he was able to withdraw his. And I'm not even going to ask you this question because you don't even know the answer.
Mm-hmm.
Okay, so it's one of 2 things happened at the airport. Either he was requested to withdraw his admission and he was just sent home and then he didn't get deported, or they literally deported him at the airport. It's one or the other. We would have to get his records to find out. If he was asked to withdraw his admission, he still will be able to come back in 2 years unless they're going to find that he made a misrepresentation by saying on his prior entry that he was coming on an ESTA visa and then filed an adjustment within the first 30 to 60 days. So that's it. there's an issue number one. Issue number two is when he re-entered the United States a second time, did he withdraw his admission or was he deported? We don't know, but I can find that out.
Okay.
So he may need one or two waivers to re-enter the United States.
Okay.
You are a law school example of how to do everything incorrectly with immigration. Hold on. I would suggest you don't do one more thing without a good lawyer because you've screwed up your life. Hold on. Onika in the Bronx. Onika. Hi, Onika. Onika in the Bronx. How are you? Onika. Onika. Going once, going twice. Goodbye, Onika. Let's go to Simone in West Palm Beach, Florida. Simone.
Hi, bros.
Hi, how are you?
How are you?
Good.
I'm fine. Yes. My question to you. Well, I applied for a visitor visa back in my country,
Right.
and however, I stated on the form that I was in a common law marriage. However, I came here in the U.S. and I overstayed. One of my kids filed for me, and got everything started to work. And then a couple months after, they called in for an interview, and they asked if I am married, and I said no. And they keep asking the question, and I said no. So they said, well, it's on my visa form. However, they denied me of my green card. They said I should file a waiver form, which is the I-601. We did, and they denied that as well.
Well, you can't file a waiver. This is what happened. When you got your visa, you probably, or I don't know if you did it or the travel agency did it, but on your visa application, you claim married when you were single. And people do that to try to get a visa because the visa denial rate for single people is greater than the visa denial rate for married people. And the reason is that a married person has more of a reason to return to their home country to be with their spouse. So when you filed your adjustment, you said single, and then they looked up on your visa application, you were married. And they said, okay, now you lied. But if you're being filed for by your children, there is no waiver for that. You could only get a waiver through parents or a spouse. Do you have parents or a spouse in the United States?
Yeah, and they gave 30 days to appeal.
Do you have, I didn't ask how many days they gave you. I asked you a question. Do you have parents or a spouse in the United States?
No, I did not hear that. Sorry, no.
Okay. So then, unfortunately, you can't get a waiver. So either you have one of two choices. You can, in the future, get married to a U.S. citizen to get your green card and file a waiver. Or because that's how you would get a waiver. Or you can argue, I never lied. I did not make a misrepresentation. I don't know what that argument would look like because I would have to go look through your paperwork, but those are your options. You probably should use a lawyer at this point. Okay, hold on one second. Joy in Lake Charles. Joy.
Hello, Brian.
How are you?
How you doing?
Good. How are you?
I'm good. I have a couple of questions, Brian. I filed I-130 for my husband filed I-130 for my kids, and which is a citizen, and this month making a year, 2 years, which I will file for the I-130. And before we file the I-130 for my kids, when my husband filed for me, it was denied. I got a work permit, and later on they denied it, and my green card, and they told me because I'm married before, I said I'm married in Africa, and I came here and blah, blah, blah. So, well, we were filed again, like a waiver and something like that.
Do you got your green card? That's all that matters.
No, I didn't get my green card. They denied.
They denied it again?
No, the first time. The first one.
Do you have a green, Joy? My question to you. Why does nobody answer my questions today? I don't understand. When you call, listen to my question to you.
Okay.
Do you have a green card today?
I never have green card.
You did not get it. So why are you talking about your children?
because my husband filed for them when he denied the first time. The first time was
Joy, if you didn't get a green card, your children aren't getting a green card. You got to worry about yourself first.
Okay. Now,
right. So if you didn't get a green card, it's because the government says you're not legally married. He's not your husband, because they're saying you were married in Africa or wherever you were married. Is that correct?
Okay. Okay. Yes. Okay. We refile again. That's what I'm trying to explain to you. That when I filed the first time, when my husband filed,
I understand what you're trying to explain to me, but I don't know why you're asking about your children. It's about you first. Your children can't do anything till you get a green card. So let's work on you first.
Okay, so now, until that's what I want to know. So when my husband refiled for me and the children, so I have to have my green card before my children can have the green card? That's what you're telling me?
Where are your children?
They're in Nigeria.
Nigeria will not approve your children's green cards until you get approved. You file 2 separate applications. They're going on two separate roads or tracks, or however you want to look at it. But even if your kids get an appointment in Nigeria, they're not going to get through until you get your green card.
So I have to get my green card before they can approve my kid, because my kid is almost 2 years now. We'll fight for them.
Not what I said.
Okay. Okay. So another thing is that when
she doesn't even understand what I said, and she's on to the next question already.
I understand what you say. I got you, Brian.
Tell me what I said, because you didn't understand anything I've said.
You said,
I said you will file an adjustment application. You have to go through the process. Simultaneously, you file for your children. They'll go through the process. If your children get a visa appointment at the U.S. Embassy before you get your green card, then they're not going to approve them. So knowing that, that's why your kid's case is taking so long, because they're going to wait on approve you first.
Okay, got you. I got what you said. Like they have to approve me before they approve my children. I got you. Yes. But the second question I'm about to ask is that when they will apply for me through my lawyers and everything, because they reapplied for me last year, and they told me they give me an appointment for November last year, which is, I don't know why it comes, why they're going to give me my appointment for New York. So I was so surprised when they told me it's New York, but I stay here. So they told me that I can't come to New York, that they have to write them for them to the immigration to interview me in New Orleans. That's where I can go for the interview.
Do you live in New Orleans? You live in Louisiana. That's where your interview would be.
Yeah, I live in. Yeah, I stay in Louisiana. Like I have to get immigration that is close to my state.
Correct.
Okay, so that's what they told me. So, and since November up to now, I've never heard nothing. So I don't know what is really happening. I never hear anything from the immigration, from my lawyer.
They say you committed fraud the first time around, so they're investigating you. That's what's happening. If your adjustment application has been pending for 2 years, they're violating your rights. I can tell you 2 things, okay, not knowing your entire case. One, government thinks you committed fraud on the first time around, so they're investigating you. Number 2, I can tell you 3 things. Number 2, your kids are not going to get through till you get through. And number 3, even if the government is investigating you, you still have a right to an interview within a reasonable amount of time. So if your case has also been pending for 2 years and the government hasn't scheduled you for an interview, and your kids are still pending 2 years behind, 2 years also, then it's time to start threatening the government with what's called a pre-litigation mandamus, a threat to sue them in federal court, just give you your day in court, give you your interview. You have your husband has a right to get you a green card within a reasonable amount of time, not 2 years later. So those are the 3 things I can tell you based on what you told me. Now, all the intricacies of when, how, and why, I would need to see your file. So hold on 1 second. Let's go to Martha in North Fork, Virginia. Martha.
Hi, Brad.
Hi, Martha.
Hi, Brad.
How you doing?
Good evening.
Good evening.
So I have 2 questions. My first question is I came here on the F1 visa, and I got married last month. So my visa expired. I graduated in 2020. I got pregnant in 2020, had a baby with my husband now. Then he was my fiancé. But we got married last month, and we wanted to put in the application
Great.
for, like, he wants to file for me.
Great.
But the issue is because I was out of status and I was working to support myself as well, even though my work authorization expired after the OPT, the 1-year OPT.
Let me, you're married to a U.S. citizen, right?
Yes, I'm married to a
Okay.
U.S. citizen.
So if you're married to a U.S. citizen, what the law says is any unlawful employment is forgiven. So if you worked unlawfully, being married to a U.S. citizen, that unlawful employment is forgiven and cannot prevent you from getting a green card. What could prevent you from getting a green card is lying about unlawful employment, saying, I never worked, and then the government finds out you did work. Now you're lying. So tell the truth and you'll be fine.
Okay, good. And that's what I've done on the form.
Good. So
the second question is, I wanted to run, so I got the form I-765, form I-30, I-30A, I-131, I-485, I-693, and I-864. I wanted to make sure if I had all the forms right. Or
okay, let's just go through it one more time. You need an I-485, an I-130, an I-130A, an I-864 affidavit of support, an I-765 for the work permit, and an I-131 for advance parole. So yeah, it sounds like you got everything right.
Okay. And the issue with the affidavit of the support is my husband does the Lyft, and you know with the Lyft, they get this huge income, and then when they take the expenses out, everything is literally very small. Sometimes,
well, if his income, his net income is you're a family of 3, is below $30,000 a year, then you'll need a second affidavit of support from somebody else.
Oh, so it's not the gross income, it's the net.
Net income. It's net income. Correct. So it sounds like you'll need an affidavit of support from someone else.
Okay. And then the other question is, what are some of the documents I can add to these forms? So the medicals, everything, I have the sealed copy. I added it to the form, but I know I have to add like some pictures and those things. I wanted to find out what are some of the things I can add.
Well, you need to prove you're in a legal marriage. That's number one. So your copy of your marriage certificate, proof your husband's a citizen, proof if you were previously divorce certificates, copy of your visa to show that you made a legal entry into the United States. And then you need proof it's a real marriage. It starts with a copy of your child's birth certificate. Obviously, that's proof of a real marriage. Proof that you and your husband live together. So any documents with your name or your husband's name with an address that's similar, that would work. Or joint documents with both your names on it with the same address. Photos of you together with friends and family. That shows a relationship. Financial documents like a bank account together, or tax returns together, credit card bills together, anything that shows that you're both jointly liable for the debts of your marriage. Submit as much as you can, the more the better.
Okay. And I put all this together with the forms, correct?
Correct. Copies, not originals.
Copies, yes. Yes. Okay.
All right. Good luck.
Thank you so much, Brad.
All right. Let's go to Kevin in Dallas. Kevin.
Hey, Brian.
Hey, Kevin.
Hey, good evening.
Good evening.
Yeah, I was trying to ask regarding my case. I filed a VAWA. Then in the process of filing my VAWA, then before they approve my case, I get married. Then I filed for my marriage days. Then with time, they not approve my VAWA. But when they approved my VAWA, because they said somebody told me, I called you one time and you said because they approved my VAWA after I married, that it's too late. Then now
This is what the law says. I don't know what I told you in the past, but this is what the law says. If you get married before your I-360 VAWA is approved, then that's the end of the VAWA. If you get married after your I-360 VAWA is approved, then that's okay.
Okay. Then the problem what I'm trying to say now is that I've for my marriage base now, I've filed for like 13, let me say a year now, and I've not got a work permit for the marriage, but they sent me work permit for VAWA. But when I called immigration regarding my marriage,
well, let me put it to you this way.
Okay.
You have a VAWA adjustment filed.
Yes.
You cannot file a second adjustment through the marriage. You have to withdraw the adjustment portion of the VAWA first. You can't have two adjustments filed. That's why you didn't get a permit on the marriage.
Like the VAWA, it was just the I-360. I didn't file for adjustment.
Okay. Then
yeah,
I don't know the answer to why you don't have a work permit yet. I would have to review.
Yes, that's what I want to tell you. Hold on. When I called them regarding the work permit, they told me that the VAWA are the one handling my work permit for my marriage. That's why I don't know. They said I should write to the VAWA that they are the one that is handling my...
I think you need a lawyer. That's my opinion. Okay. You can write all the letters you want. You're not getting a work permit.
Okay. Okay, I might...
Hold on one second. Let's go to Danny in Windsor, California, excuse me. Danny.
Hello?
Hi.
No. Can I have like 1 minute? Okay. Hey there.
Hi, Danny.
Hi, we're seeking an immigration lawyer.
Yeah.
Because my friend is detained at the Port Isabel Center.
Why?
We want to know what for seeking asylum.
Okay. How long has your friend been detained there? Danny?
I'm here the 26th, since the 26th.
Okay. And your friend was caught after the change in the laws on May 12th?
Yes.
Yeah. Well, that's a problem now, because if they ran across the border and then got stopped, then you can't apply for asylum. But now the argument would be that...
Okay, I understand.
Right now, assuming that, we can get before an immigration judge, the argument would be, I never ran across the border. I put my toe into the United States and I was held. So I'm still basically at the border. So I never actually crossed in, was undocumented. That would have to be the argument. I would need to speak to your friend. We would have to investigate this. That's probably why your friend's still detained in detention at the moment. But hold on 1 second, okay? Let's go to Sam in Sacramento, California. Sam.
Hi, Uncle Brad.
Hi, how are you?
Very well, thank you. Uncle Brad, straight to the question. I actually want to get your opinion. I mean, I valued it so much. I came to the United States through, C1 visa. I came to conditional residence. So I just want to know when the actual time I can put in for my citizenship based on
excuse me. I thought you said C1, CR visa, you said.
Yeah, I came here through CR visa in September 2018. Yeah, but the marriage was unable. We divorced 2 years ago, but we have a kids together. But I've put in for my removal of condition. That has been pending since I put in since September 2020. I've not gotten anything back from them.
Right.
I got an extension. I traveled a couple of months back. I stamped my passport for another 1 year extension, which will last till December of this year. So I want to know when I can put
Your
in for
citizenship.
my citizenship.
You said you got
under
your
my
green card in
birthright.
September 2018?
Yeah, I came to United States. I entered through the United States September 11th, 2018. So I want to know, based on 5 years rule, because I'm unable to claim the 3 years rule because we are not together.
Yeah, so anytime,
So
anytime after July 15th.
Okay, anytime after July 15th, I can file in for my.
That's,
okay.
I mean, if I did the math right in my head, that would be less than 90 days before the 5-year anniversary.
Okay. Do you advise if I should just wait all through July? Probably putting in for the first week
Put
of
in
August.
Put in August 1st. You want to be safe.
August 1st. That'll be better. Okay. And another thing, I actually want to know which route, the route that
Actually, July 11th of July. If it's September 11th, so June 15th to July 15th is 30. July to August is 60. No, put it in July 1st. You don't have to wait till August. Put it in July 1st. It's fine.
Okay. I can put in July 1st?
Yes.
Oh, okay. All right, great. So, and second, the last question is I want to know the route that will be perfect. I mean, faster for me if I want to bring my mom to United States. Is it true visit visa when she can come in and I adjust the status, or I should just filing for her? I just want to know.
The best thing is if your mom gets a visitor's visa and then wait 90 days and put in an adjustment for sure. It'll be a lot faster. But you got to become a
lot faster.
Yeah.
I know. Yeah, I'm here. And how long will it take for her? Because I have a younger brother, which
assuming she's going to adjust her status right now, it's taking about a year.
A year. Okay. All right. Great. Thank you.
You're very welcome.
That's it.
Okay.
Thank you, sir.
My pleasure. Let's go to Jessica in Topeka, Kansas. Jessica.
Hi. My question was based off the poverty, the 100% poverty. When getting divorced from my husband, because I have a fiance, my husband at home, we don't plan on splitting the house.
Okay.
So we're keeping it as is on title, and so the factoring in, because also I have my brother that lives with me, so it's when factoring in that income is, do I still need to personally make the 125%, or is that factored in? Like,
wait, you started off, you're getting divorced from him. What are you talking about? Factoring
not for the immigrant. I'm a U.S. citizen. I'm married to a U.S. citizen. We're getting divorced. It has nothing to do with my fiance at the moment. So the question is, we're going to get a divorce, and when we're not splitting the assets, so I'm going to try to bring my fiance here. And I don't.
Okay, I understand. So what you're saying is you're married right now to a husband who's a U.S. citizen. You're getting divorced, and you're in love with this man in another country, and you want to bring him here on a fiance visa, and you'd like to know what the requirements are in terms of the affidavit of support.
Yes. So how the income is factored, because.
Okay, so the income is based on are you working or you're unemployed right now?
I'm unemployed, but I plan on saying obviously work will have to be an option. Just haven't got there yet.
Okay, so you can use the value of your home less whatever mortgage is owed and factor in 20% of that. So for example, if you own a home, I'm just making up numbers, and your home is worth $300,000 and you have $100,000 in a mortgage left on the house. So you have equity of $200,000 on your home. You can take 20% of that $200,000, which is $40,000, and put that as money towards reaching the poverty guidelines. And the poverty guidelines for two people is $25,000, and then you would be fine. I probably would suggest getting a second affidavit of support anyway, because a lot of times when you value the house, how do you value it? They question it a lot. So
I'm like currently, I want to say for legal purposes, my husband and I weren't splitting the house up at all. We're keeping it just because we know that
and I would, if that's the case, my advice would be to find a second affidavit of support from somebody else.
Is that just friends or family, or
Friends
is it?
You can pick any one of 320 million people in the U.S.
Okay.
All right. I think that'll be the easiest thing. Okay.
And I have one other question.
Sure.
He has debt over there. He wanted to know, would that affect the visa at all?
Absolutely not.
He has current.
Absolutely not.
All right, that's it.
All right. Good luck.
Thank you.
Okay. All right. Let's go to Akram in Naperville, Illinois. Akram.
Hey, Brad. This is Akram. How are you?
Hi, how are you?
Yeah, I'm good, Brad. So I have a few questions. So first of all, I'm a permanent resident almost 3 years now. So when I originally filed when my wife filed my petition, she was a green card holder, but in the process before, like when I became when I got my green card, she became a U.S. citizen. And as soon as she became a U.S. citizen, within 2 weeks, USCIS issued an RFE asking to provide the proof of citizenship of my wife, which we did. And I got a 10-year green card without any condition because I got it after 3 years of marriage. At the category on the green card, it says IR6. So my question is, am I still eligible to file after 3 years, regardless of the filing status at the time of filing? Because she was a green card holder at the time of filing.
No.
So
no, it's 3 years from the date she became a citizen, or 5 years from the time you got your green card, whichever is first. You don't get to count the time she was a green card holder.
Okay, yeah. So since then, since the time I got the green card, she is a U.S. citizen still.
When did she become a U.S. citizen?
She became a U.S. citizen in November 2019, and I got a green card in April 2020.
Okay, so then, yeah, so April 2023, you're still married in a bona fide marriage. You can do your citizenship right now.
And also, Brad, should I have to take my wife to the interview? Because
not necessarily. Not necessarily.
Okay, but does she need to wait like in the waiting room if there is?
No,
like,
not necessarily. You just got to be able to prove you're in a bona fide marriage with her still.
Okay, and my green card interview was waived because of, I don't know, because I had a lot of information.
Great.
Yeah.
All good stuff.
Will that have an impact on my citizenship interview?
No, as long as you can prove you're in a bona fide marriage. No.
Okay, and other few questions, quick questions, like if this is for my friend brother, so he got a B1 B2 when he was a minor, 14 years old, and now he's 21. The visa he got was 10 years. He traveled to US 2 times on that visa already, but before he turned 18. Now he has a new passport.
By the way, that's not me falling on the snow. I don't know why that picture is there. Continue. What is your question?
Yeah, sorry. So the question is, so his visa was on his old passport, and he got when he was 14 plus years. Now he's 21. Can he still travel on that visa to the United States? He still has a valid visa until
he has a valid visa, yes.
Okay, and related to that,
I can't answer every last question from every one of your family members, but I answered all your questions. You let your family members call. We have to get to other people, but thank you for calling. Okay.
All right. Thank you. Bye.
All right. Let's go to Michelle in Fort Lauderdale, Florida. I apologize. I don't know why these pictures are up like this. You should be looking at my face. There I am. How are you, Michelle?
Hi, Brad. Let me turn on this. Okay. Hi, Brad. So,
How are you?
I have a question. I'm fine. Thank you. I married a U.S. citizen February 2022. Start the filing May 2022. Got the receipt and everything. Have work permit from July 2022. But since July 2022, I have seen that my I-130 adjustment of status is still saying actively review.
Okay.
And also on April 21, 2023, a new message saying to actively review by the USCIS.
Great.
My question is, it's 14 months now. Do you have an update? Why is it April 2021.
I don't have any update on your particular case. No. How would
Okay,
I?
next question. No, I mean,
I don't know.
like 14
I don't know
months.
I don't know, but some cases should take approximately 12 months, but I don't know what you did on your particular case. But being actively reviewed is good news. It means that somebody's looking at your file right now. So hopefully it will be very soon.
Okay, next thing. I didn't put in the additional documents in like medical and wedding pictures. I just do use the basic like marriage certificate, I-94. You think that's the reason why it didn't?
I don't know. I didn't handle your case. I don't know.
Okay.
I don't know the answer to that
question. Is there a number that you can provide me with to call them? Like instead of getting.
You can call immigration. They're not going to give you any answers. You're talking to an outside company who answers their phones. What you need to do is take a deep breath and relax. It's 14 months. It's not 14 years.
Oh,
I don't
Lord.
I don't know what's going on in your particular case, but obviously they're adjudicating it because they're actively looking at it as we speak right now. So my presumption is that you will hear from them very shortly. Just take a deep breath. You'll be okay. But you're asking me what is going on with your particular case. How would I know? I wouldn't.
Okay.
But it sounds like everything is going fine.
Okay.
All right. Good luck.
All right.
Let's go to Augustine in Houston, Texas. Augustine.
Hello, Mr. Brown.
Hi, how are you?
I'm good. Please, I have a question. So my wife got approved for asylum case, and I testify in front of the immigration judge. And after, we went back to the attorney to know the next steps. And attorney said the box they're supposed to check, which include my name, which supposed to include my name as a spouse, they didn't check the box. So can you advise what's next I can do in this regard?
Your spouse got approved for asylum, but they didn't. I don't understand the question. Say it again.
Okay, so there was a box that is supposed to check to include the spouse in under our case, so that I can get derivative of asylum as well. But while we went to the attorney said that they forgot to check the box, and it was an oversight on their end.
Well, obviously, it's fixable if you were married to your wife at the time that her asylum was approved. So all of that is fixable. I would need to look at the actual forms to see what was done, and I can certainly fix it. The good news is that you were married to your wife when she got approved for asylum. So the law says you're entitled to derivative status, even if your prior lawyer screwed up, whatever word you want to use. Okay, so it's fixable. Okay, how we fix it, what you should do, I got to look at the papers and then I'll tell you what to do. Okay, hold on one second. Let's go to Tony in Lewiston, Maine. Tony. Tony. Tony.
Are you hearing me?
I hear you.
Yes. I have a few questions that I'm married to a U.S. citizen. We got married in May. I was on the H-2B visa. I put in the documents in October, got all the receipt notices, did the paperwork, did my biometrics in December, but I still haven't gotten any answer from USCIS about my work permit. But it's still saying that it's been reviewed.
When did you file?
I filed in October. They received it on the 25th of October.
Did you get an RFE for additional documents?
Yes, just for his taxes.
When was that?
In December, and they received it on the 23rd of December.
Okay, so count 6 to 7 months from the 23rd of December. That's when you'll get your work permit. Because you didn't complete your case until December. So probably June, probably end of July.
Okay, the next question is, during this time with my husband, we had a domestic dispute where we fought, and he told me to leave the premises. Will this affect my case?
Yes, because you're no longer in a bona fide marriage with your spouse if you're not living with him. So at this situation, you have two choices. You can try to work things out with your spouse, or you can file as abuse spouse if your husband's abusive and take him off the case. But you living apart from your spouse, the government not knowing why, you'll be denied. So you either have to tell the government why you're living apart, which is he was abusive, I couldn't live there anymore, if that's the case, or you get back together with him if he wasn't abusive, because living apart from him is not going to work for you.
Okay. So how could I start filing the VAWA
You
at
call
this
me.
moment?
You call me. Hold on one second. Let's go to Mamadou in Huntsville, Alabama. Mamadou.
Yes, ma'am, bro. Mr. Brown, how are you today?
Good. How are you?
I'm good. I got like 3 questions here. I'm married to a U.S. citizen, but I came with a fiancé visa. So after marriage, I got a 2-year green card. Just shortly, we just get divorced. So now, should I file now for the self-petition? I have to wait until the 90 days
You
expires.
have to wait the 90 days before, and then you file the self-petition I-751. It's the I-751 waiver based on a bona fide marriage that terminated in divorce, with proof you're divorced or going through a divorce, and proof that you were in a bona fide marriage, which is proof you were wife and you live together, and proof you had a financial relationship. But you don't do it now. You wait until the 90 days before.
Okay. So the second question is like, can I go with the 2 years green card to our home country?
Yes.
Okay. So the other one, should I notify immigration before the self-petition about the divorce?
No.
Oh, okay.
Okay.
Thank you.
All right.
Thank
Good luck.
you.
All right. So that's our meat and potatoes. And we're gonna go. By the way, we're gonna remind everybody. Let me see where I am on my case here. On my show here. Gotta remind everybody that if you didn't get your immigration questions asked and answered, you can always follow me on Instagram at Brad Show Live. You can follow me on Instagram at Real Brad Bernstein. You can follow me on TikTok at Brad Show Live. You can follow us on Twitter at Brad Show Live. All of these different social media platforms, you can reach out to Spar and Bernstein to ask your immigration questions. You can also go on our website at www.lawsb.com, and you can send us a text message right from our website and ask your immigration questions as well there. Send us an email from there as well. And later in the show, I will be answering your questions, the ones that you wrote in the comments in our social media check-in. But right now, for the next 1 minute and 30 seconds, I want to talk about our personal injury department. At Spar and Bernstein, we do handle personal injury claims as well as immigration cases. Some people may not realize that if you get hurt on someone else's property, you can file a premises liability claim, and that includes falls. And there are 2 kinds of falls: a slip and fall accident where the person falls backwards, and a trip and fall accident where the person falls forwards. And this personal injury video, I explain the most common conditions that cause slip and fall and trip and fall accidents, and what the most common premises accident injuries are. Let's watch. The most common conditions for slip and fall accidents include wet floors, oily floors, accumulation of ice and snow, defective staircases, unsecured rugs or carpets, hitting extension cords, loose or broken floors, sidewalks, steps, debris such as dirt, gravel, or rocks, deep holes in the sidewalk, sloped slabs holding snow or rainwater. The most common conditions for a trip and fall accident include
cracked sidewalks, raised manhole covers, materials left on the floor, or material or debris at a construction site. The common injuries in premises liability cases typically include bone fractures, neck and back injuries, soft tissue injury, traumatic brain injury, spinal cord trauma and paralysis, concussions, herniated and ruptured discs, lacerations, organ perforation, eye injuries, shock injuries, and burns. At Spar and Bernstein, we offer a free initial consultation to review your case and recommend next steps.
Unfortunately, accidents do happen, so save our telephone number when accidents happen, 1-800-529-5465. That's 1-800-LAW-LINK, 1-800-529-5465. In case you or someone you know or love is injured in an accident in New York, you just dial the number, you hang up, and it's saved in your phone for life. You never know when you're going to need good lawyers, and we are very good lawyers when it comes to personal injury. So you dial the number, you hang up, you've got it saved for life, locked in your phone. God forbid you or your loved one gets injured in an accident. You never know when you're going to need really good accident lawyers. And we help people all the time. And we help people when they need it the most. All right, let's go to our social media check-in. Let's do it. Let's see what's going on. All right, our first question. I cannot pronounce this person's name. Let's call him Ho. I filed an RFE for an I-485 physical examination. The case is based on VAWA. I submitted for 1 month. How long does it take to process the application? Up to 120 days, but hopefully you'll get it beforehand. Good luck on that. So if it's just the medical, then you should get it pretty fast. By the way, my mistake. I have to ask the VIP questions first. We're going to do that right now. My apologies to the VIP people. If you join our Brad Show Live squad, our Brad Squad on Facebook, our Brad Squad VIP membership group on Facebook, you will get your immigration questions answered first. My apologies to our VIPs. I went backwards today, but we're going to answer our VIPs right now. I submitted my adjustment. Crystal Perry asks, I submitted my adjustment of status in January. I just got approved for my EAD. How long before I can expect to get my green card, F1 child of a U.S. citizen over the age of 21? It takes about 1 year, Crystal, so good luck. Crystal also with a second question. My daughter was on the original I-130 but did not adjust with me. Once I get my green card and file for her, will they use my priority date from the old I-130? Will I have to file a new I-130? I'm planning to bring her and do the adjustment of status here. If she is in the United States on legal status and you file the adjustment of status while she is in legal status, you do not need a new I-130. She would just follow to join you. So good luck. Pismis Nana. My file was to be sent to court, but never was. It's not on the docket. I got a temporary back valid till November 19. The coronavirus happened. What will happen if I book a flight now? Thank you from Germany. If it sounds like you're in removal, so even if it's not on the docket, if you return back to Germany, you self-deported. So go speak to a lawyer first. Kristukumar Gade. I was on a J1 visa in 2018. I met with a car accident, a DUI. After 15 days, I came to my home country for 15 days due to a family emergency. I booked a round-trip ticket. When I was coming back, the airline people stopped me. I was deported from my own country. What steps should I take to come back to USA? Will I be able to come back? Well, I don't know. The DUI sounds like you were the one who was drinking and driving, so we would have to see what happened with that criminal case. And I don't know what happened on your J1 visa as well. So we would need to look into both your immigration records and your criminal records to see how you can return. So it's one of those situations where it's like going to a doctor. I say this all the time. You go to a doctor and you say, doctor, I need an operation. Well, I got to take an x-ray first. So this would be my x-ray. I'd have to look at your criminal records, look at your immigration records to see how I can operate and help you. But it sounds like you have a criminal record for DUI, maybe even DWI. Patricia Marie, my husband's spousal visa case was approved in May 2021 to go forward to NVC. I'm a U.S. citizen. We've been married for 4 years. Due to losing our sponsor, COVID, my cancer, and my loss of income, we could not continue the process. We have a new sponsor, and I filed for early retirement. Is it possible to reopen the case and continue with the NVC? It is possible to reopen the case as long as it has been less than 1 year since they have closed it. So they will close it and then give you 1 year to reopen. So I don't know when it was closed, but hopefully it was closed within the last 12 months. Then you get an extra 12 months to reopen it. So hopefully that is the case. I don't think you'll need to start over, but probably I'd speak to a good lawyer. All right. So those are our VIP questions. We're going to go now to back to our comments, and let's see where I left off. And we have Searing Coker with a question. Hi, I got a 2-year green card through marriage to a U.S. citizen, and now we're divorced. Can I travel with the 2-year green card outside the U.S. and back? I think I answered this question. The answer is yes, you can. Dion, is there any way around the COVID vaccine for a green card? Yeah, you can file a waiver based on religious or moral grounds. AJ, if you have a valid green card or expired green card and extension letter, and you got no problem with the law, you should be good. That's not even a question. All right, Femi, my wife will be going for her immigrant visa on the 23rd of this month in Nigeria. My 2022 tax return is not out yet, but I have my old tax transcripts from 2021, 2020, 2019. Will that be okay? If those are the last 3 you have, and you have not filed 2022 yet, you would have to show it's on extension, then you would be okay. If not, you got to get the 2022s. Jumok, please, any updates on I-751? I filed for removal of conditions 2 years ago. Yes, it's taking about 3 to 4 years these days. Let's see what else we got here. CE user, I-765 approved. How long before the I-45, I-130 travel card is approved? Travel documents are taking at least 90 days past the work permits. Sued, can you get citizenship with a dismissed petty theft case? At some point, yes, you have to prove 5 years good moral character. So I don't know when the dismissed petty theft case was. The Tish Masreth. Hi, I checked no instead of yes on item 61 public charge on I-45. I received an RFE recently. Do I have to resubmit the whole I-45 or just item 61 once USCIS send me RFE for part 8, item 61 missing answer? Just answer the question yes or no in letter form, and that would be fine. You don't have to file a new I-45. Marco, hello, sir. I came to America with a tourist visa to visit the place, and a cousin of mine, she wants to adopt me, and I'm 20 years old. Well, good luck on the adoption, but you have to get adopted before you're 16. It won't help you getting adopted at 20. What you can do, if you're under, by the way, what you can do if you're under 21 is special immigrant juvenile. If she wants to become your legal guardian, prove that you've been abandoned or abused by your parents, and that's why you have to stay here, and it's all done before you're 21, perhaps you can do it as a special immigrant juvenile, but not as an adoption. Marco, I'd like to know the same question. I already answered that, Marco. Just me, what to do if you get a letter stating intent to deny? Answer it. They want to deny you. I don't know why they're denying you, but you got to answer it positively. Get a good lawyer. Des, great show, Brad. How can I get utility bills in both our names if I don't have a social? You can't. But when you get a social, then change it. So it's a problem, but eventually you'll get a social. And Riyada Al-Hashemi with a question. I filed a VAWA and requested to put my I-45 hold in abeyance. Now, my VAWA just got approved. What's next? Do I have to notify NBC about my VAWA approval? That's what, yes, you should. Write them a letter and tell them that you're with proof of the copy of the I-360. Write them a letter saying my VAWA is approved now. Please continue the process. Does I-130 ever expire? No, it does not. And it could get revoked, though. Rita, how long does it take the I-45 that was on hold after VAWA approval? About 1 year. All right, so those are our social media check-in. I just finished it. Wow, not a lot today. And we got to go now to our games. We're going to watch the first part of a new squad versus crew game. Right now, the score in this ongoing competition series is squad 11, crew 10. So the crew needs to step it up. Squad member Kalisha Perry and crew member Eliza Bertrand are meeting in a rematch in a game we're calling Tradition Expedition to see how much they know about cultural traditions around the globe. Play along at home and let us know how you did in our comments. Let's watch.
Hey Brad Squad, Vanessa Contreras here today for another edition of our ongoing Squad versus Crew series. We all know culture and tradition vary across the world, which is a huge part of what makes our planet such a diverse and fascinating place to live. So today we are going to have a rematch between show fan Kalisha Perry and our crew member Eliza Bertrand.
Versus.
Who are about to match wits on their knowledge of cultural traditions around the globe. Some are quite fascinating and unique, and even the most seasoned traveler may not know. So test yourselves and play along at home, Squad, in a game of Tradition Expedition. How are you guys feeling?
Great.
Let's see. Okay, let's do it. Let's get started. Are you guys ready?
Yes.
Let's do it.
Okay, first question. What country has the unique tradition of hanging out in cemeteries? Is it A, Poland, B, Norway, C, Sweden, or D, Denmark? Okay, let's see your best guess or answer in 3, 2, 1. Okay. The correct answer is D, Denmark. So here we go. In Denmark, while many people might prefer to hang out at parks, people in Denmark may convert their cemeteries into areas of socializing. These cemeteries are well manicured and where locals enjoy gathering when the weather finally begins to warm up. Assistance Kierkegaard in the country's capital, Copenhagen, provides a perfect example. Plus, you'll be hanging out in great company as many famed Danes are buried here, including Hans Christian Andersen. Next question. What country has the unique tradition of pointing with your thumb? Is it A, Japan, B, Malaysia, C, the Philippines, or D, India? Let's see what you've got in 3, 2, 1. The correct answer is actually B, Malaysia.
Oh my God. I almost guessed that.
Some countries, including the United States, find the act of pointing with the index finger to be abrasive and rude. In Malaysia, it is customary to gesture towards things with the thumb, as this is seen as a more polite option. Yes. Here we go. What country has the unique tradition of spitting on a newly married couple? Is it A, Iceland, B, Italy, C, Greece, or D, Colombia? Okay, let's see what you guys got in 3, 2, 1. Okay, so this point goes to our crew. The correct answer is C, Greece. To first point out, Squad, no one is actually spitting on anyone. This is very unsanitary. But in Greece, it's traditional when a bride and groom get married for guests to pretend to spit at them, as it is associated with good luck. Also, Greeks do this tradition on other occasions, such as baptisms, to acknowledge a baby's good health and beauty.
I only know that one because of My Big Fat Greek Wedding. Because as they're going down the aisle in the movie, all the relatives are like, toot, 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 as they're walking down.
Wow.
Hey, I turn to movies for a lot of my education too, okay? So next question. What country has the unique tradition of Groundhog Day? Is it A, Thailand, B, United Kingdom, C, New Zealand, or D, the United States? Let's see your answers in 3, 2, 1. There it is. Yes, you both get the point, squad and crew. The correct answer is D, the United States. Here in the US, we have the custom holiday and tradition of Groundhog Day. Since 1887, on February 2nd, the nation waits patiently to see if the groundhog sees his shadow. If he does, it means there will be 6 more weeks of winter. And if he doesn't, spring will come sooner. The holiday first began in Punxsutawney, Pennsylvania, and was brought to the US by German immigrants. And those who are fans of Bradshaw Live know that Groundhog Day has a special place in our hearts as Bradshaw Live's mascot / intern, Groundhog Sam. Bravo, Sam, bravo. In what country do many people practice the unique tradition of kneeling or lying in prostrate when greeting elders? Is it A, Kenya, B, Ghana, C, Morocco, or D, Nigeria? Let's see those answers in 3, 2, 1. Okay, so the answer is actually D, Nigeria.
Oh.
Yep, Nigeria. So, for members of the Yoruba people, an ethnic group that largely resides in Nigeria, greeting rituals are taken quite seriously. This is especially true in regards to greeting elders. When an adult approaches, Yoruba youths are expected to drop to their knees in greeting. More specifically, women kneel when greeting, and men typically lie in prostrate. These gestures are a sign of respect and deference for elders of the community.
Oh, we're done. I'm sorry. So Eliza's ahead of Kalisha with a score of 2-1. It's close, and the game's not over yet. So we'll play the final part and see who wins next week on Monday, June 12th, when we air live again between 5 and 6 p.m. All right, we're ready to go to speed rounds. Are we ready to do it, Jill? Let's do it. All right. On a count of 3. We're not ready yet. Are we ready? I don't know. Are we ready? Okay. 3, 2, 1. Let's go. Can someone be deported if they have a master hearing in court? Yes, you can get deported at a master hearing. Does the USCIS BIA rule apply to a U visa applicant? I don't know what you're talking about. What BIA rule? What if I'm in the U.S. on a visitor's visa? Can my mom file for my adjustment of status if you're an immediate relative under 21, or if your prior date is current and you're in legal status? Will a misrepresentation for an F1 visa in 86 affect my approved I-130? Yes. Can a federal criminal record 22 years ago prevent you from getting a green card? Absolutely, yes. How long does it take to receive advanced parole work permit? 6 to 9 months from filing. How long can you travel with advanced parole? I usually don't stay out for more than 60 days. Can you fly out of the U.S. with a green card? Of course you can. Can I file an I-130 petition K3 at the same time? Yes. Oh. What's the last question? When applying for a green card, is it a problem if you and your spouse live in different states? Of course, you have to prove it's a bona fide marriage. Oh, well. Didn't do it. Damn. That's a damn. That is a damn. All right. What can we do? Let's do comments of the day. Comments of the day. All right. First comment of the day. The first comment of the day is Wendy Brown. Brad is the best. I like that, Wendy. Thank you. Jessica Leamy, Brad, with all the immigration news, we need this. It's our way to stay up to date with what's happening in the immigration world. On behalf of all the immigrants on this show, thank you. Appreciate it, Jessica Leamy Davis. Dawn Harriet, thanks for that very important, informative schmoozing with Brad. Thank you, Dawn. Appreciate that. Crystal Perry, Uncle Brad's on a roll, except until speed round. Kenise Berg, Brad knows the answer to every immigration question. Most of them, yes. And that is it. Those are our comments of the day. Thank you all for watching. I really appreciate it. And I want to remind everybody that unfortunately we've come to the end of our show, but we're going to be back next Monday, June 12th at 5 p.m., between 5 and 6 p.m. on Facebook and YouTube. Until then, remember to like and subscribe to Bradshaw Live on Facebook, YouTube, Instagram, TikTok, and Twitter for lots of great content, immigration and personal injury information, and more. Have a great evening. Have a great week. Stay safe. Be blessed. And we'll see you all this time, same time next week. Thanks for watching.
So, Sam, as part of the production, we have to say this disclaimer at the end of the show. Do you mind reading it for me?
Okay, but you know, Brad, I have to do everything around here.
Forget it. I'll do it. The proceeding was information only and not specific legal advice. Consult an attorney about your individual situation. Prior successful results do not guarantee a similar outcome in the future. To make an appointment with the Spar and Bernstein law firm located at 225 Broadway in New York City, call 1-800-529-5465. That's 1-800-529-5465. Easy to remember, 1-800-LAW-LINK. That's 1-800-LAWLINK. Once again, make a call to 1-800-529-5465. And of course, link up with the law offices of Spar and Bernstein, located at 225 Broadway on the 5th floor. If I were you out there, make the call, make the link, make the connection, make it Spar and Bernstein. 1-800-LAWLINK. That's 1-800-529-5465. And visit us now at our Connecticut office, 221 Main Street, Suite 501, Hartford, Connecticut. Visit us in Connecticut or in New York at 225 Broadway. That's 1-800-529-5465. 1-800-LAW-LINK, 1-800-529-5465.
What are you doing?